And so one of the most important tasks of the judicial branch is to ensure that the majority will doesn't crush the rights of minorities. And so if the majority might want to enact a law that violates individual rights, and the Supreme Court, as the judicial branch, they can step in, even though they're not elected, they can ensure that democracy prevails by ensuring the respect of minority rights.
So how do judges make decisions? Judges are bound by applying the facts to the law, and they don't care and they cannot care about public opinion. They have to be divorced from whatever the public opinion is of the day, because if that were the case, then the law would never be static. It would always be changing based on whoever's in power at the time. One of my favorite slides is a quote from Justice Antonin Scalia, which says that to be a really good judge, you have to, at some point in your career, decide a case that, not the way that you want to, but the way the law actually requires you. And that's the mark of a good judge, because you're following the law, you're applying the law to the facts. And when you do that, I think that's what a good judge is supposed to do. So how do judges make decisions? Again, we hear the facts of the case from the litigants and from the attorneys, and then we apply the law. In many instances, it's applying the U.S. Constitution or state legislation or federal legislation. For criminal cases, we abide by sentencing guidelines to determine how criminal defendants are to be sentenced when they are convicted. For the procedural process, there are rules of court. There's rules of criminal procedure, rules of civil procedure that allow for the process to go forward. In the civil cases, the judge's mandate is to provide fair, efficient, and just resolution of all cases. And that's what the mandate is for all circuit or all civil judges in courts. The trial court decisions can be appealed. Even in Florida, there are 4 courts. There's the county court, the circuit court, the 4th district, or there's a district court of appeal. In this area, it's the 4th district court of appeal. Even the 4th district court of appeal cases can be appealed, and the final say would have been Justice Pariente and the Florida Supreme Court once the cases are appealed from the district court of appeal.
And then if it involves an issue of U.S. Constitutional law, it can be petition. There can be a petition to the United States Supreme Court, which has been done on occasion during the 2 decades I sat on the court. Bush v. Gore being the most notable of them. They were wrong.
So words do matter, and the song that started this whole event was a song about more than words, and that's the theme of this presentation. And I think there's a meme that goes out with eat grandma or eat comma grandma, and the two mean very vastly different things. If there's no comma between eat and grandma, someone may want to eat grandma as opposed to telling your grandma to eat. So this cartoon, I think, encapsulates why and how words matter. I don't know if you can read it, but initially it says, I've always thought it's weird that they say defendant is innocent until proven guilty. And then the other person says, weird, what's weird about it? And then she says, well, technically, a defendant should be considered innocent unless proven guilty. And the person's like, You know, I never really thought about it that way. Until makes it seem as though it's inevitable. Guilt is inevitable. And then the final response is, it's fine. It's a fine distinction, but an important one. From now on, I'm going to say innocent unless proven guilty. Words do matter. And to support that contention, the Constitution does require interpretation because there are words within the Constitution that are not distinctly and definitively defined. There are aspects of the Constitution that are. For example, the age for a president. There's no wiggle room around it. It's clearly stated the age for a president has to be 35. But there are other areas of the Constitution that does require you to have interpretation. For example, I don't know if anybody knows what amendment this is, but it says Congress shall make no law abridging the freedom of speech, First Amendment. But what is speech? Well, back when the Constitution was originally written, speech was words on a piece of paper. Now you all have Twitter, Instagram, Facebook. I'm not cool on my social media platforms, but all of that is now considered speech, or is it considered speech? And, you know, it's the seizures. That's from the Fourth Amendment, but what's reasonable? You know, can the police just come beat down your door because they think that there's drugs in your house? Or do they have to go through some process to get a warrant to determine whether or not there's probable cause for you to actually come in? And what's reasonable between the two? The Constitution. Constitution doesn't tell us that. That's what the judiciary is for, to help interpret what is or is not a reasonable search or seizure. This is an interesting one, and Justice Periente, I don't know if you were on the bench at the time, but the says, nor excessive fines imposed, nor cruel or unusual punishments inflicted. Well, back, I don't remember when it was, just maybe in Florida, there was, you could kill a minor. If a minor had committed a serious enough crimes, the death penalty could be imposed and the person could be executed. And that case went up to the U.S. Supreme Court, and the U.S. Supreme Court struck down the Florida law and said that that is cruel and unusual punishment. That's an interpretation of the Constitution, because the U.S. Supreme Court, were you on the bench at the time?
Well, I'll give you actually what happened, a little background on it, because it was, we had there's the United States Constitution that we're mainly focused on, but there's also a Florida Constitution that has its own set of rights. We have in the Florida Constitution an explicit right of privacy. The United States Constitution does not have an explicit right of privacy, which was, someone was asking about whether the U.S. Supreme Court might proceed from Roe v. Wade. Harder under the Florida Constitution as far as a state banning abortions. But at the time, our Constitution said cruel or unusual punishment. And we interpreted actually it was a 16-year-old that was sentenced to death, and a majority of our courts said that that was unconstitutional. The legislature was catatonic about it, and they put an amendment on the ballot, a proposed constitutional amendment, changing it to cruel and unusual. But then several years later, the United States Supreme Court, under the 8th Amendment, which this is, determined that executing a minor, anyone under 18, was unconstitutional. Again, over a strong dissent by Justice Scalia, et cetera, saying you got to interpret the Constitution based on what was going on at the time the Constitution was adopted. And back then, you could execute essentially whoever you wanted, so there shouldn't be an age limit. That's just really a question of the state's rights, not of federal jurisdiction. So no, we actually, what I feel was the right side of this.
Right, it was the legislature that enacted the law that the Supreme Court struck down.
Yes, exactly.
All right, then the next one is, nor any state deny any person within its jurisdiction the equal protection of the law. So we're going to talk a little bit more about this in some actual cases that were decided by the U.S. Supreme Court. But what does it mean to treat people equally? So now we're going to talk about some cases that interpret the Constitution, where the judiciary interprets the Constitution. The last slide that I showed you says, again, no state shall deny to any person within its jurisdiction equal protection under the law. These are my two of my favorite slides, because this is how actually reach real people like myself. So let's talk a little bit about Brown versus Board of Education. This was a case that was decided in 1954. And at that time, in 1954, 17 southern states had segregated schools, meaning whites only went to school with whites and blacks only went to school with blacks. This case involved 5 states: Kansas, South Carolina, Virginia, Delaware, and Washington, D.C. There is a party for each of the states. One of them was Mr. Brown, who was a welder, whose daughter had to walk 7 miles to school when there was a school a mile away that you couldn't go to because it was all whites. So he, along with other parties in each of the states, separate but equal mantra, which means that you could have segregated schools. And Mr. Brown himself lost his job. There was one of the parties in one of the suits, he was a pastor, his church was burned out. All of those individuals that fought for this case suffered some personal loss to enforce this, our all rights to have integrated schools. The case introduced us to Thurgood Marshall, who was the first African American that was appointed to the U.S. Supreme Court. He represented those individuals. He was with the NAACP, he was their chief counsel. This case also shows a conflict within the executive branch because the Department of Justice supported the NAACP in their effort to try and undo that separate but equal mantra. And President Eisenhower disagreed. Nonetheless, they went to the U.S. Supreme Court, and 9 white men determined that separate but equal was not equal, and they struck down the state laws requiring integrated schools. So the reason we are all sitting here, blacks, whites, Hispanics, and the like, is because of Brown versus Board of Education, which 9 justices faced Earl Warren, who was he authored the opinion. They wanted to get rid of him. They wanted to remove him from office because at the time, especially in those 17 states, it was a really unpopular decision. And that's an example of judges doing the right thing. Part of the backlash was, I think he was in Alabama, George Wallace, who said segregation now, segregation forever. He refused to enforce the law. It required what's called Brown 2, which is another Supreme Court case in which the Supreme Court required that those that law with all deliberate speed. So if you've ever heard of that phrase, that's where that phrase comes from. It's Brown 2, where the U.S. Supreme Court required those 17 states to desegregate those schools with all deliberate speed. Another case that applies the 14th Amendment, the Equal Protection Clause, which applies personally to me, is this. I call it a love story, and in fact, it's very interesting because the parties' names are truly loving. That's their names, Mildred and Richard Loving, and it has been memorialized in a movie. I recommend you all watch it. It's a very touching story of just true love. This was 1967, and there were 16 states that had anti-misogynistic laws, which meant that different races could not marry. You could not have interracial marriage. They equated interracial marriage with polygamy and incest. And the whole belief system was that they wanted to have racial integrity. And so they had these laws that people of different races could not marry. Well, Mildred and Richard met each other, and they loved each other. Mildred was half African American, half Native American. Richard was Caucasian. They fell in love. They're from Virginia. They both lived in Virginia, which is one of those states that had those anti-misogynistic laws. They wanted to get married. They wanted to make it legal. In order to make it legal, they drove to Washington, D.C., which allowed for interracial marriage, and they got married. Mildred was very close to her family, so she wanted to go back to Virginia to live among her family, to be able to spend time with her family, and she was arrested. She and Richard were arrested, and they were convicted, and the judge said he wouldn't impose any sentence on them, but the thing that had to happen was the Lovins had to move out of Virginia for 25 years. So they moved back to Washington, D.C. because they didn't want to go to jail. Mildred was distraught. She wanted to be with her family. So she petitioned Robert F. Kennedy and asked him for help. And Robert F. Kennedy told her to go to the ACLU and the ACLU represented her, and they sued the state of Virginia. If that law wasn't in place, I wouldn't be able to get married because my marriage would be illegal. One of the interesting facts about this Loving versus Virginia case is one of the ACLU lawyers was Justice Cariente's professor. So I want to thank Justice Cariente and her professor for allowing me to be able to marry the man I know.
You know, I really, I love listening to Judge Rowe talk about those cases because we never, ever can forget that what we are doing as judges and justices, as Professor Tunick said, is whether you call it anti-majoritarian, what you're really doing is allowing a country to respect all individuals, regardless of their race, religion, and Loving was used by the U.S. Supreme Court most recently to allow for same-sex marriage, which, I don't know exactly what the reaction of Loving was in the southern states, but as you may recall, there was a lot of far worse than heartburn in many parts of this country about allowing that. And actually that plays into something we'll discuss shortly. So we had the First Amendment, and you saw that North Korea and Russia had a First Amendment. So we've got the First Amendment, and the freedom of speech is probably the most well-known. So the question is, what is speech? So this was Texas versus Johnson. I don't know if you can see the picture, but there's a flag there. And during a protest, not near anybody that could be injured, a protester decided that they should set the American flag on fire as a protest against our country. And some of you might look and say, I mean, that's horrifying, setting a flag on fire. And in fact, there were a lot of people in this country that agreed that that was a terrible act, and the person that did it was, not that they were from Texas, but Texas had a law that said that flag burning was illegal and was a crime, prosecuted. So Mr. Johnson appealed that decision all the way up, and the United States Supreme Court, when we say 5-4, I think you all know there are 9 individuals on the U.S. Supreme Court, 7, by the way, on the Florida Supreme Court, said that that law was unconstitutional. And Justice Brennan, who became really an icon in his day for not only protecting individual rights, but also crying out to state courts to say, you've got to also be there to protect rights. And I think that the idea is, and I have over the years taught classes in middle school, civics classes, and different ideas that we think, well, if speech is offensive, we ought not allow it. But the whole point of speech, again, you hope that they're going to be civil in what they do, but is that it's freedom from the speech that we would find disagreeable, so that everyone has a right to speak. And I think that the dissent, and actually one of the dissenters became a judge, I think that Justice Stevens, who recently died, was in the dissent. One of the high purposes of a democratic society is to legislate against conduct that is evil and offensive to the majority of the people. So you think about that, and what Professor Tunick said is that, yeah, it was offensive definitely to a segue, because Justice Scalia was prone, when he was on the court, to very eloquent statements. And here he said, if I were king, I would not allow the people to go about burning the American flag. However, we have a First Amendment, and it says, right of free speech shall not be abridged. Now, you might say, well, but that's not speech. It's burning the flag. No, it's not taken literally as to what speech it is, as long as it wasn't someplace where there could be harm. Well, I remember I graduated law school in '73, the outrage around the country about this flag burning decision was unanimous, and there was talk of having a flag burning constitutional amendment. Of course, that would take a lot of work on the parts of the state. I don't know how much flag burning is going on in this day and age. That was really sort of a big thing during the Vietnam War when I went to college. People would burn their draft cards or, something that was a symbol of this country and say, we don't agree with what you're doing. So that's Texas v. Johnson, the First Amendment. Now going on to that wonderful Second Amendment, let's talk about that.
So the Second Amendment, can you read what it says? It says, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And what does that mean? And next slide. So for close to 200 years, what it meant was that people who are part of a well-regulated militia have a right to bear arms. And we call that the collectivist right interpretation, that you have a right to bear arms only insofar as you are a member of a militia. Now, a militia, does anyone know the difference between a militia and a standing army? Okay, the militia is the people, back then before we had professional police and so forth, the people were the state militias. So if there was an issue, the people would be called to serve in their militia. They were not a standing army, that is, they were not professional soldiers. And the idea was that the states, during the Constitutional Convention, they were concerned that the new federal government would set up a standing army that could conceivably, suppress the states. And so the idea was that the states put maybe go back to the previous slide, that the states wanted to put the Second Amendment in to make sure that everyone understood that states could still have their own militias, and the members of those militias would be people who would have their own arms, which they would then gather to serve in the militia, so that the standing army that the federal government set up would not overpower the states. And that was the idea. But in 2008, for the first time, and I'll talk briefly about a few cases beforehand, the Supreme Court, in a 5-4 decision, said, and we'll just read Justice Scalia's, what he says here, there seems to us no doubt, on the basis of both text and history, that the Second Amendment conferred an individual right to keep and bear arms. And so what he's saying is, no, the Second Amendment is not just about a right of a collective militia to have its members bear arms. It's a right of an individual homeowner, let's say, to keep arms to protect their castle. Now, this was new, 2008. Back in 1938, there was a case called U.S. versus Miller, where Congress enacted a law requiring all people who possessed guns with barrels of less than 18 inches to register those guns and pay a tax and get a stamp in return. So Congress regulated these arms. Now, barrels under 18 inches, the idea was that these were not the sort of guns that would be used as part of a well-regulated militia. The Supreme Court, in this case, upheld Congress's regulation, and it said that the Second Amendment doesn't really apply. It only applies to weapons that one uses as part of a well-regulated militia. Then there was another case even an earlier case, 1886, Presser versus Illinois, where Illinois passed a law saying people cannot bear arms during a parade. And so someone challenged this, saying they have a right to bear arms, the Second Amendment. The Supreme Court said the Second Amendment doesn't even apply to states. It applies only to Congress. And then just one other example, there was a case in 1982, Kwiatkowski versus the Village of Morton Grove. The Village of Morton Grove passed a law basically banning arms that were under 18 inches. And the Supreme Court upheld that because, again, this was a regulation of arms that individuals would carry, and the Second Amendment only applies to arms that are part of a well-regulated militia. So the question is, who's right? What does the Second Amendment mean? Let's go to the dissent from Justice Stevens in Heller. He's sort of going to repeat what I just said, or I'm going to foreshadow what he's going to say. The Second Amendment was adopted, this is the dissent, so he lost, was adopted to protect the right of the people of each of the several states to maintain a well-regulated militia. It was a response to concerns that Congress might disarm the state militias and create a national standing army. Neither the text of the amendment nor the arguments advanced by its proponents evidence the slightest interest in limiting any legislator's authority to regulate private civilian uses of firearms. So this raises the question, what do you think? What does that Second Amendment mean? It's called a prefatory clause. The prefatory clause, maybe go back 2 slides, says a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall not be infringed. Why is that prefatory clause there?
Because the militia was only enacted or put into use in case the state was at risk of not being free. That was its main intention.
So the intention was the intention was not to protect individuals from bearing arms, for protecting their loved ones.
It was more so that the body of the militia could protect the states more than anything else.
Just so a collective right. Justice Scalia says in Heller that the prefatory clause announces a purpose of the Second Amendment, but he says that it does not limit the scope of what follows. And what do you think?
What do I think? I mean, I think if you're an English major, you would say that, of course, it was to apply only to the right of militias. And interestingly, when I went to law school, and it was certainly prior to Heller, we went from the First Amendment to the Fourth Amendment, because anyone know what's in the Third Amendment? The quarter, right, so even where it's placed, that you have to quarter, troops or whatever it says, shows to me this, and remember, this is something that the states wanted to limit the federal government, so that they were looking at protecting themselves from, from the overreach of the federal government. But now, even though it was 5-4, it's the law. However, if we go to the majority opinion, it still says the right was not unlimited. So this idea that nowadays there are people that say that they have a right to own an AK-47 or an AR-15 there is nothing in the text of that amendment where Florida has its own individual right to bear arms, actually. So that was probably passed understanding the government, that the federal Second Amendment didn't apply, that they would be able, still the legislature would be able to regulate what kind of firearms or weapons that you had. So it's very controversial, and now it's sort of a rallying cry. A lot of people, if it had gone the other way, there would have been an outrage on the other side. So you start to see these very divisive opinions that we talked about: flag burning, integrating schools, and then the Second Amendment case. So we go on then to the next. And Jessica, we really left you out here, so
you guys are all wondering why I'm here, right? So this is where we get some more audience engagement. What would happen if judges decided cases based solely on public special interest or political influences? And we're really looking to you guys to add your insight on what you think this world would look like if that happened.
Well, the laws of this country would then be severely politically motivated and biased, rather than having something based on justice, based on subjective opinion instead.
I agree. Does anyone else have any other thoughts on what could happen in addition to just subjective lawmaking?
It would be very difficult for minorities to gain rights.
I agree. Or whether you're talking about minorities, in this case, racial minorities, whatever the minority of the day is at the time, just like right now, for the last couple of years, we've had a lot of focus on gay rights, that they've mentioned. So anything else that you guys think could happen? Go ahead, in the back.
I mean, one function of law is to provide stability and predictability. So if public opinion changes all the time, we vote for a Democrat for president one year, then a Republican in another. So we wouldn't have laws probably.
Correct. It'd be very hard to know every time which law you're supposed to be following in which area, correct? Do you guys have anything to add to this that you guys want to make sure that students know about?
No, I think what is very important is this public opinion part, because although earlier it was said that judges don't look at public opinion, honestly, it's very hard not to know what public opinion is, but it's fickle because it's so fickle. If you look at polling, one day people are thinking this, the next day that. It would be a very unreliable way, and really, as Judge Rowe had explained, judges must follow precedent, follow statutes, and so the whole trust, public trust and confidence in the third branch of government would be destroyed.
I think another fear that we saw just a few years ago when Justice that there's that threat to the judges themselves, that if it's public, if it's based on public opinion and special interest groups, that the judges probably don't feel safe to be able to interpret the law the way they're supposed to, because they're under threat from possibly not being retained or not being reelected. And we really did see that happen, and it was, for an attorney, it was quite a scary time for us to see that happening to our court system.
I'm glad that they were not successful, but that's what we were talking earlier in state courts. Most state courts do not adhere to the federal model of lifetime appointments. There are some that think lifetime ought to end at not sometime before the age of 100, but it still is, it gives stability. It may maybe one long term. So the system in Florida is a dual system, and maybe I know that Professor Borman discussed it in her class, but we're going to about the way Florida and other states work.
So we'll go to the next slide.
Ruth has a question.
Okay. I just wanted to say that with last, it would be very easy for interest groups and lobbyists to buy court decisions from judges.
And the truth is that there are a lot, because there is money placed into state judicial elections, that there are a lot of the public that believe that judges are deciding cases based on, say, who contributed to their campaign, because it's so antithetical to what we think judges should be doing.
I also want to add that considering now when judges make decisions, that it affects people's lives negatively too, if they were to act based on what is that special interest in political influences, yeah. So they have to decide based on somebody's life or livelihood, it could be affected in a negative way, which prevents justice from being served properly.
Also, the public isn't always, they can't always make a well-informed decision because they just don't, the average person doesn't have the background or the knowledge to make a well-informed decision based on, the law.
just to sort of dovetail from what you're saying, you know, a lot of times the papers will criticize a judge for a ruling or an opinion, and a lot of times the entire fact pattern is not given to the public, so they're just, you know, it's Tuesday, so I'm gonna rule this way. I encourage you, before you decide to criticize a judge's ruling, to actually investigate what it was that the judge actually did. What were the facts that were presented before the judge for the judge to make that decision? Because oftentimes, people are believing that the judge is making a determination based on a different set of facts than actually the facts that were presented before the court. So just to add to what you're saying, you know, one of the reasons why I love being able to do these panels and to, you know, go with Justice Periente is to inform you all, voters, to investigate. Just don't accept what is given to you. Determine for yourself whether in fact the judge ruled in that particular way based on the facts that were presented, and not the, you know, the 2-minute soundbite that was maybe given, you know, in the article or the newspaper or the news report.
And I think a lot of us make determinations based on our emotions, and we can count on the judge to set that aside for us.
So on that note, moving to the next slide. So what are 3 positive labels and 3 negative labels you guys have heard judges use to describe judges? Let's start with, we'll keep it narrow. Let's start with the positive labels. What are some positive labels you've heard about judges?
That judges are generally considered to have a lot of wisdom.
Wisdom, smart. What else?
Fair.
Fair, that's a great one. Any others?
Unbiased.
I'm sorry?
Unbiased.
Unbiased. Yeah. What about temperament? Would you want your judge to have a good, even temper, or do you want them to be someone who, you know, flies off the, you know, starts yelling every other second? I mean, those are the sort of labels that I think you can hear sometimes. What about negative labels?
That judges are often portrayed to be outdated in certain ways.
Outdated? Yeah. How would you describe that? In what way?
Like-
An example?
Like pop culturally, like not up to date with societal trends and things.
Okay, so maybe they're not as familiar with public opinion as maybe they should be, even though they're not supposed to let that sway them.
Exactly.
Your legislators from the bench.
Yes, that is definitely a negative label we've heard, especially during that retention fight a few years ago. What else? Any other negative labels?
Hold on emotions, especially like heartfelt speeches, or kind of too into what's happening. They won't like consider those emotions.
The emotions that they're heartless or cold. And I think we saw a lot of that, I just have the name in my mind, but it was when I first started practicing law, the woman that was in a vegetative state.
Oh, we're talking about Terry Schiavo.
Terry Schiavo, that was cases where I think that was played up a lot in the media as to the judge's decisions not being emotional enough.
Bigoted.
Bigoted, yes. Okay. So the dangers of labeling judges, we're gonna turn this back over to Justice Periente.
This was something that I think, well, I experienced firsthand during, as Jessica mentioned, during the merit retention, but it's really been something that has proliferated, I'd say, in the last 20 or 30 years. That is, and with the advent of the various 24-hour news cycles, but even more with, you know, Twitter, and I'm not going to be able to say all the media, but, you know, all of those things. I used to think Facebook, that was a big deal. So here is the problem is that labeling judges, and I think you mentioned it, starts to reduce whatever that judge did or the decision that he or she made to a soundbite. So are you going, one of the labels that you will see on here, on a lot of commentators talking about it, is activist, that a judge is an activist, as opposed to the idea that judges are reaching down for a case where the court is and they're deciding it, and there's a lot behind what went into the case. So, but by saying activist, there's a negative assumption. The issue of, I think I've lost this one about, conservative, liberal, Republican judge, Democratic judge, we tend to use these labels, but, if you took Justice Scalia in the case involving the First Amendment and flag burning, would that be a liberal decision? So, but no one would call Justice Scalia a liberal. So it's really a question of, was he following a consistent judicial philosophy? I mean, my argument with Justice Scalia was that under the Second Amendment, if he looks at the text, it's really hard to ignore that prefatory phrase. And then the next one, and I think you mentioned it, is judges have to engage in interpreting statutes. We don't make the law, we interpret statutes. If the legislature or Congress were perfect and they knew, their wording and definitions were precise, there might not be a reason for interpretation. So are you going to say that what the judge did was interpreting the law, or legislating from the bench, or legislators in black robes? And believe me, again, I certainly was accused of many of those labels. So now here is an ad that ran in 2010. I want you to listen, and just note what labels you hear. It was from Iowa, it was not Florida. Oh, okay. Your IT guy, he thought he didn't have any more.
Jim to the rescue.
Activist judges on Iowa's Supreme Court have become political, ignoring the will of voters and imposing same-sex marriage on Iowa. Liberal, out-of-control judges ignoring our traditional values and legislating from the bench, imposing their own values on Iowa. If they can usurp the will of voters and redefine marriage, what will they do to other long-established Iowa traditions and rights? 3 of these judges are now on the November ballot. Send them a message. Vote no on retention of Supreme Court justices.
So you laugh about this, but go to the next.
Activist judges.
I mean, it's so great to hear. You laugh about it now, but actually that campaign was successful. It was about same-sex marriage under the Iowa state constitution, and their money came in from out of the state to support a retention election that's against 3 of the justices who made that decision, and they were voted off because you only needed 51%. Yes.
I was just gonna say that like one of the main issues with voting on judges on whether they should be retained or not is for a lot of voters in just the United States and within like Iowa or Florida, not for that. Just seeing that, telling them to vote no was like, okay, I don't really, I care about my state senator, my state representative, but they're just judges, so that's enough for me, I'll vote no. And so they don't actually know anything about the rulings or decisions that judge has even made, other than what the ad tells them.
Right, and it's an effective ad because it's also talking about taking away guns and all these other, as if they're gonna destroy the family. The problem, and again, I could do a whole lecture on merit selection and retention. I still say it's better than a partisan judicial election where there are 2 people running against each other, because in a judicial retention, the judge has already been vetted through merit selection, so that you hope that the qualifications of that judge are such that they deserve to be retained unless they did something unethical. But the kind of labels, what labels, yes.
Tradition.
They're ignoring traditional, let's see, what I think yeah. Again, you have activist judge, they were becoming political. that was their take on it. If anyone ever is gonna go into like messaging, public relations, these have been tested as labels that really evoke in the voter a negative opinion. So I say, here it is, that was 2010. 6 years later, the United States Supreme Court made a decision that same-sex marriage bans were unconstitutional. Obviously, there was no ability to remove those judges from the bench, and I'm sure there would have been people that would have wanted to do it, or even have judicial elections.
So how does the use of labels influence public perception of the courts? What do you guys think about that? What do you think obviously we touched on briefly, what was the intent of that ad? It was trying to influence the public perception, right? In what way?
Make the courts look illegitimate.
Right, that's the word, delegitimize.
Make people lose faith in it, basically.
Right, and just sort of a one-sided faith in the system, right? What else? However, what other ways can labels influence public perception?
In a way, it seems to me like they were demonizing almost those judges, and saying, like, they were making a lot of false claims, like they're imposing same-sex marriage, or they're imposing their values. That's not. But obviously, like, you know, in retrospect, like, there can be work because there's statistically sort of out.
Right. I mean, what do you think those labels were trying to do in that ad? Were they trying to go to the voters' fears and exploit those in some way? Certainly that's how I look at it.
I feel like a lot of voters' fears is that they themselves as a voter they're not being respected, and so that's why one of the labels that they assigned was not appealing to the will of the voters. But like as like Tuning said, it's not a judge or justice's job to represent the will of the voters. It's a judge and judge's job to represent like what they feel is a correct decision regardless. You know,
Right.
so.
And in fact, that ad and those labels is actually trying to undermine exactly what a judge is supposed to stand for, which is being fair and impartial and not following only public opinion when it's not the right thing to do. They were actually criticized for doing what they were supposed to do, right? And that's very scary when you think of it in terms of this branch was set up to be a checks and balances against the other two, and they're trying to undermine that exact thing that was created. Anyone else want to add anything to this? Okay. So, I think we talked about some of these positive, like, what would you guys want in a judge? If you walked into the courtroom today to have some case decided, whether it's a breach of contract case or heaven forbid a criminal case, try to stay away from those people. What do you want your judge to look like? What are those characteristics?
That they're objective.
Objective is a great one.
In terms of their knowledge base, to be extremely experienced and seasoned.
Experience, season, those are good.
Like you mentioned before, temperament.
Mm-hmm. Temperament is what she said.
Diverse.
I'm sorry?
Diverse.
Diverse, right. Would you want a judge who looks somewhat like you? Maybe not in every courtroom, we wouldn't all be so lucky, but you certainly want to see some of them, right?
I was gonna say considerate or understanding.
Right, consider and understandable, and I think that goes to the temperament in many ways.
I'd like to see consistency, in every case,
Correct.
depending on what the case is about, consistency in marriage decisions.
Right, consistency, and I think we see that a lot in the criminal arena with these judicial sentencing guidelines. There's been articles and studies about how criminal defendants, depending on whether it's their racial, whether they're black or white, they are treated different. And they've looked at that, and they're supposed to be having the same sentencing guidelines, right? And that I think that would probably scare a lot of people.
I was gonna say integrity too.
Integrity. That's a good one. Anything else? Is there one in particular that's most important to you guys of all of this?
Don't be a cold bench judge. Make me feel as though I can actually convince you on my side.
Don't be a who?
A cold bench judge.
Cold bench.
Meaning interact with the.
Give me the illusion as though I can convince you to go to my side.
Okay.
That's a very, that's a very interesting thought. As a Supreme Court justice, I was very active in my questioning, and there were others that just would listen. I also oral argument place to ask those questions. But I think you'll find among, someone mentioned earlier, you want a judge that's not divorced from the emotions of what's happening. But in fact, you really do need to be able to be respectful and a careful listener, and have a good temperament, but you can't allow yourself to be ruled by your emotions. You feel like you want to cry if you have the victim or whatever it is, that might be grounds for you to get off the case. So it's a fine line, being respectful and a careful listener, and also consistent, but explaining the reasoning. A lot of times the judges overrule, and that's hard. I mean, it's hard to be a trial judge. When you're on the appellate court, you have much more time to look over the issues, but judges are making split-second decisions many, many times a day.
You want to be empathetic, but you can't sort of put yourself in that person. You have to, again, maintain your role as the judge, because as Justice Oriente said, if you go too far with your sympathy, the other side may say, well, now you've gone too far, and now I want you off the bench. So you have to, it's a really tricky fine line to make sure that you are communicating to the person that's speaking to you, that you understand what they're saying, that you're empathetic to what they have to say, but you're still going to maintain your role as the judge and make the just and right decision based on the facts from both sides.
So in terms of those characteristics, I think you guys actually hit almost all of them. I think the only ones we didn't talk about was service to the community. And I think that is an important one. You do want to make your judge as part of your community in some way, and respect of colleagues. And I think that was an important one too, that people probably don't think about very often, that you want your judges, because I think that goes to their temperament. You want to know that they also respect their colleagues. You might have differing opinions, whether politically or otherwise, but that they respect that they're all just there to follow the law.
And I'm sorry.
No, yeah, go ahead.
Just to add, like, 2 points. The service to the community helps me, just using myself as an example, sort of connect with the community, because on the bench, I don't mean to be a sob, it's kind of isolating. You have to be very mindful of who you associate with. You can't lean too far to one side or another. So, allow, like, events like this is very helpful to me to connect with the community in a way where I'm hopefully serving the community, but also getting feedback from you all as to, for example, what you all are looking for in a judge. I remember on Friday, I was at another event, and one person said they want judges to smile, and then another person said, I don't want anybody to smile at me. So it was kind of interesting to understand, how people, are expecting their judges to be. And then the whole respect of the colleagues aspect, that also is very important. The fourth BCA will overturn me, and I, may not necessarily like it, but it's their role, and their role is to look over the decision that I made, because usually I probably made it in a split second, and they have an opportunity, for months to look over what I did and apply the law that I probably didn't have at my fingertips in that split second decision. So, one of the best things, I don't mind people appealing, because first of all, you're exercising your constitutional right by appealing, and then I get to learn something if I made a mistake, because the appellate court will then outline for me what it was that I did wrong and the legal authority by which they made the decision.
No, I was just going to say, these are factors that in the merit selection system in Florida, that the application that you submit is voluminous, and then they do see from the judges what's their opinion of you as if you were a lawyer, and so it's a vetting process that next time, and it will be interesting, there won't be another judicial election in Florida until 2020. By then, some of you may be gone from Florida, but all of you will be able to vote. And I always thought it would be a good idea to have, like, at FAU or another college campus, have the judicial candidates come, and now you would know, you wouldn't ask these questions like, well, what do you think of the death penalty? Because that's not really something there should be answering, but what is your background? What makes you qualified to be a judge? Not that you have the best campaign slogan, so to speak. So that's in the judicial elections, you've got public.
Oh, so leads me to, this is a perfect segue. This is one of the reasons why we all come out. I'm blessed to be part of the National Association of Women Judges, and they, along with the Informed Voter, produced these slides. And it's done with the intent of communicating with the public, to allow the public to understand the judiciary, because as Justice Periente said, it's kind of scary sometimes when folks do vote for judges, they don't necessarily know who they are. So I've heard instances in other counties where people like to have an A in their name because that means their name is going to be first on the ballot as a judge, because they think that the person's going to vote for the first letter name on the ballot. When, Judge Applebaum, for example, may have no knowledge about anything to do with the law, but Judge, Zimmerman does, because then they're going to be on the bottom of the ballot. So one of the things that I told you before that I like to do is so that you all can know that you really do. Judges are an important part of our Constitution. They're an important part of our United States, and it's important for you all to be knowledgeable about the judges that are sitting in your jurisdiction. And because we all vote for judges in this state, you need to be informed about who the judges are, what their qualifications are, what their temperament is. Go to court sometime. I invited a table, I think, to come on a courthouse tour. You will be fascinated, I was, at what goes on in that courthouse. I did not know, as a lawyer, going to the courthouse every day, how that whole building functions and how many people it takes to actually make that whole process work. And this is one of the reasons why I love being part of this. And so I just encourage you to be informed. And you can connect with us. We're on Facebook and Twitter.
All the old social media.
Exactly. With Justice Periente, we went to, I think, was it an elementary school? We were told that Facebook is for old people. I didn't know that before.
Well,
So just have one more video. Yeah. Hopefully we'll get it ourselves. Yeah, we'll still keep going.
Our Constitution is celebrated as the backbone of our democracy, but our Constitution cannot survive without fair and free courts.
Americans look to their courts for fairness, free from the influence of politics and partisanship.
Learn how you can help keep our courts fair and free at the Informed Voters Fair Judges website, or join the conversation on our Facebook page.
Our courts are what they must always be, fair and free.
Thank you.
So much. Thank you all for being here. They will stick around for about 10 minutes for questions.
We have a couple, we have about 3 minutes.
Do you want to ask me a question?
4 minutes. Any questions? Yes, and I would give us your name and you answer some questions.
I'm Chase Foster. I'm a political science major. And I have both Dr. Tunick and
okay, well done.
so,
What year are you?
freshman.
Oh, good. Okay, what is your name?
So my question is, a lot of people are really quick to change their opinion on like how precedent works, based on if the previous case agreed with how they would rule. Like I believe Professor Bourne was mentioning, I don't remember. Neil Gorsuch, Justice Gorsuch, there's a case where in his dissent or opinion, he was setting himself up for like a future abortion case. But a lot of people are quick on one side to say that the precedent shouldn't be upheld. But if the previous decision had been reversed, their entire opinion on the term precedent would be completely different. So I just want to get like an actual judge's opinion on that.
Well, precedent plays a very important role for trial judges and even the intermediate appellate court, because they're bound to follow what the opinions are. When you get to the Supreme Court, there are reasons that you can receive from precedent, but you must follow a very strict, you should, guidelines before you unsettle the law. And the one that has been the center of the most recent election and others in states has been Roe v. Wade. On the other hand, when Hillary Clinton was running for president, she said that she would appoint judges that would overturn Citizens United. That's the case that has to do with this right of free speech of corporations. And I think that's equally problematic. You don't really want to have a judge or justice committing that there, is a platform. But I think we are in truthfully in an increasingly polarized environment. The justices that are now being appointed to the U.S. Supreme Court all have been recommended through what didn't exist in my day, the Federalist Society. You should look, they have a disproportionate impact on who is being selected for both federal judges and for the Supreme Court. And I think that for all of you, this is about becoming involved. These things happened because there were some very smart people thinking, how can we influence the influencers? So it really is up to you in coming elections to be involved and also to be really informed about what's going on in your court system, and whether you agree or disagree, to hopefully, that's why elections have consequences. Governor DeSantis got elected, and three people that replaced myself, Justice Quince, and Justice Lewis. There is now only one woman on the Supreme Court of Florida, and no African Americans. This is the first time in probably 40 years. And he followed all the recommendations of the Federal Society. So I can say something that I wouldn't have said while I was still a sitting justice, which is there is a danger to the judiciary. You all should be very aware of what's going on. And I'm not saying there's nothing specifically, but you're doing the right thing by being here, by taking courses by excellent professors at this honors college. And I mean, I'd probably put all of you in high positions of trust just based on your answers today.
Speaking of Supreme Court justices that have been recently appointed, Justice Brett Kavanaugh has thanks for that. He's been facing a lot of criticism when he was appointed and going through the whole confirmation process itself. But now that he's a sitting justice, there's been a new allegation of sexual assault against him. I wonder if there's been any prior cases of this in the past, either at the state or federal level, and like what your opinion on it?
Well, what you have to do is justices and federal judges can be removed for what's called high crimes and misdemeanors. The problem with the whole Brett Kavanaugh situation is, and I'm not saying as far as how I thought his demeanor, in the confirmation hearings was really very non-judicial, but those were allegations that were 30 years old. Not that that makes it invalid, but he had been appointed as an appellate federal judge, and those allegations hadn't surfaced. So there was a great deal of skepticism about them. But I think that impeachment, to impeach the president or a judge, you need there's a impeachment 50%, over 50%, but then the Senate, it's a 2/3 vote. So I think frankly, the reason there's a lot of talk about impeachment. So, that really horrifies me that we have somebody on the Supreme Court with those allegations and displayed such terrible judicial demeanor. But right now, I'm not sure that what is going to be done about it, because politically, the only way to remove him would be that process. And I don't think there's ever going to be 2/3 of the Senate in the foreseeable future that would actually vote to remove him. Is that it? So it's horrifying. The allegations are horrifying.
But in terms of precedent, having seen that before, we did have that locally with Judge Santino, where it wasn't an impeachment per se, but she was elected to the bench in a countywide election and was removed by the judicial,
It was the Judicial Qualifications Commission.
right, because of acts during the election that they said were improper. She was a sitting judge for several months, maybe.
Well, the difference is, again, the state judges do not have lifetime appointments, and they can be removed. And during the time I was on the Supreme Court, several judges were removed. And I have to say that almost all of them who were removed were products of an election, not appointment. So the Judicial Qualifications Commission investigates and then makes recommendations. The federal Supreme Court, there isn't a process for any authority to remove a sitting justice because of the lifetime appointment.
And it was a much higher burden in terms of what those, high crimes and treason and misdemeanors have to be. But I think it's going to change state by state. Every state's going to have their own rules and regulations of their court system at the state level. And so it will depend. But we do have, I think, a little more protections here in Florida that work to protect the court system.
Yeah, my name is Aaron, and I have a question for you, Judge Rowe and Justice Parrington. I actually have two questions. I'd like to know when and how did you decide exactly what law you wanted to study, and how important do you think it is? Well, do you think that students should work to gain experience before going to law school, or do you think that they should go right after undergraduate?
Did everyone hear the great question? Everyone hear? How many people here are thinking at some point of going to law school?
Whoa.
That's a substantial majority of those here. So great question.
Am I your name again?
Aaron,
Aaron, how did I decide to go to law school?
when and how did you decide exactly what law to study, and how important do you think it is for students to work before going into law school? Because I've talked to different lawyers and I've heard different answers.
It's a great question. Not necessarily I'm the right person to answer it. The reason is because when I was in college, I did not think about law school. In fact, I didn't want to be a lawyer. It was my sophomore year, I switched majors, and I became my degrees in broadcast journalism and psychology. So I was in a communications law class, and my communication law professor took me aside and said that I should consider law school. And I thought he was quite frankly crazy. And I sort of rebuffed him, didn't do it, and kept at me. And finally, really just to shut him up, I applied to Nova Southeastern. And I just did it really to shut him up. And then a lot of other life events happened, which is too long for me to get into. And I decided to go to law school just because I thought, well, let's try this thing because I'm good at. And it was my first, the orientation in law school when the president, the dean of the school, introduced himself and introduced us to what this career would be. And I was like, wow, where have you been my whole life? And that's kind of how I got to the bench. So in answer to your question, I don't really have an answer to your question because I didn't follow that path. My path to becoming a lawyer was not the traditional path because I truly did not anticipate being here.
Did you go straight from undergrad to law school, or did you?
No, I the next over, which so I interned at CBS, CNN, and my last job was working for WPBT in Miami. And then my uncle, who was an undercover police officer, was shot. and he wasn't supposed to live, and so that whole life event just sort of said, well, do you really want to do this whole broadcast journalism thing, or try this law school thing? So I tried the law school thing, and that's when things turned around, and everything changed.
Do you think that career experience helped you be a better attorney? I mean, I think part of your question was, should someone wait or should they go straight through?
Yes, basically what you think, like what advice would you offer based on your experience?
My advice to you is find something that you really like to do. Don't become a lawyer because your mom and dad want you to become a lawyer. Don't become, don't go to law school because your friend is going to law school. Do it because you want to do it. Do it because it's something that you think is going to interest you. Because the one thing about a career as you get older is if you do something that you really didn't want to do, when you have a bad day, you're going to hate everybody and everything about life. When you have a job that you really love to do, when you have a bad day, you're just like, it's a bad day, but I still love what I do, and tomorrow will be a better day. So my advice to you and to anyone is to find something that you really like to do. That's how I ended up here, because when I switched my major to broadcast journalism, I wanted to be a doctor, and I just did it because there was no doctors in my family. I figured I would do it, but I didn't really like it. So I like to write. That's when I became a broadcast journalism major. And so that's sort of the path that I followed. So I didn't follow a traditional path. It wasn't like I was 4 years old and said I was going to be a lawyer and I was going to be a judge when I was, none of that. I just came to this place, and it's the best place I've ever been. And I'm very thankful to him. In fact, that professor is an assistant dean at the University of Miami. He's like family to me because he truly changed my entire life with just seeing something in me that I didn't necessarily see in myself.
And she's an excellent judge, and I've encouraged her to go farther. There was a gentleman in the back that said he was deciding between being a neurosurgeon or a lawyer, which I thought, so have we helped you today decide?
You're going to be a neurosurgeon, right?
Neurosurgeon? I think the first question is there a particular path? And what I tell students and those out of college is that the best path is doing your best when you're in school, earning first-rate grades, and also seeking as mentors professors who can help also guide you. So you've got some great people again here in this college. Ironically, and I think Judge Rowe and I had talked about this, when I went to Boston University, I wanted to go into broadcasting and film. I didn't want to, back then, because I'm considerably younger than Judge Rowe, there were no women in the, broadcast arena. No women, no minorities. This was, in the late 60s. And funny me, I decided, because I was doing a documentary about legal services for the poor, I said, I think I'll become a lawyer, not knowing that there were almost no women, no minorities, and even in Washington, which was a diverse city. So I come down here to Florida. So I guess what I'd like to say, we have lawyers, but we always need good, passionate lawyers. And I also have to say, for those of you here that are, as a minority, as women, nothing against the white males here, but we're still in a white male-dominated society. And as someone said earlier, when you're on the bench and somebody's being sentenced and they're African American, and our bench in Palm Beach County is almost all white. Again, on the Supreme Court, all white now, both Hispanic. So it's important if you have that passion, and I wouldn't discourage really anybody, but in particular, those of you considering this, I think we're hopefully coming to a time in our country where those of us that have not always had a voice need to make sure we are asserting our voice in a very intentional way so that we are not locked out of a system that acted to exclude so many. So I guess, yes, that's how, and you can be in law school, you can become, you can go into politics, you can make so many other, you don't have to be a practicing lawyer. So I think it's, again, it's not the most fun education. I don't know, did you say that fun in law school? I don't know, what you went to, I don't know, I, like law school.
I tried to get, I mean, it was getting from point A to point, but it was interesting because it requires you to use your brain. And the one thing I love about this profession and being a judge is every day you get challenged. Every day you get to learn something new. And that's what I found fascinating about law school is that every day was a different challenge. Every day you got to learn something new. So your brain was always active. And that's what I really enjoy about it.
Had you decided to go to law school right away?
So I was a business major. I thought I'd do accounting or something equivalent. I really like numbers, so I thought I'd do business, and then I thought, I can't sit at a desk all day. That would be so boring. So I'm going to go to law school, and guess what? I sit at a desk all day. But I didn't know it at the time, but I'm going to do a little bit more. But that is by and large, lawyers still sit at desks quite a bit.
We go to the court.
But every now and then, but let's be honest, we're not in the court. Even if you're a trial attorney, you're not there as often as they show on TV. I was telling our table back there about that. So I went straight through. I went straight from undergrad to law school. Didn't take any time off really in between. And I will say, don't worry about that. Do what feels right to you, because I know people who are very successful having gone straight through, and I know people who are very successful having had a second career and then going back. I will say that I think in interviewing in law school, everything is, Justice Parrington is right. When you're in law school, if you make that decision, you need to study the hardest you've ever studied, because at that point, your grades matter more than almost anything else. And so having good grades is going to get you a good job coming out of law school. That whole on-campus interview experience, if you were a second career student, you tended to perform better because you had a little more life experience. They just received them better in terms of the firms that were interviewing. So that is where they have the advantage. So to the extent you think you're gonna game the system that way by having a little more life experience and then going back, it won't hurt. But then there are students who went straight through like me who got great jobs too. So, you know, I don't know that there's really an edge one way or the other. There's pluses and minuses on both sides. And I will say that a lot of coming out of law school is what you know, how you did grade-wise, and after you've been practicing a while, it becomes more about who you know, what contacts you've made, and what people you've impressed with your legal skills and everything else.
Did you go into general counsel right out of law school, or did you?
I did not. I practiced in West Palm at a private law firm of about 35 attorneys for 10 years, doing the same thing essentially that I'm doing now, commercial litigation. And I got to the point when you said, if you don't like what you're doing, you're gonna hate life. And I still love the people I worked with. It was never about the people. But the last 2 years, I really felt like I hit a wall in terms of what I was doing, what I was learning. I just felt somewhat stifled, right? It just wasn't a happy place anymore. And I knew that when I'd be driving to work and I'd start driving slower because I didn't want to get there yet. My commute was better. And again, not slamming my firm because they were amazing. They taught me so much and I wouldn't be here without that. But that is when I finally said, I need to overcome this fear of change and find something else to do. And then I found this job. And then 5 years later, I still absolutely love my job. So ask me again in 5 years, we'll see. But right now, I do love it. And I will say, if you are interested in becoming general counsel, I do think you need experience in a private firm or a government agency. You need to have legal experience under your belt. We do not hire generally straight out of law school. There are very few companies I know that do. It's not unheard of, but it's rare. We want you to have that experience. So, any other questions for any of us?
Great group up. Dr. Tuning, why did you leave the law school? Why would you do that?
So my father, who was an attorney, he sent me a check to take the LSAT because he thought I would be a good lawyer. And I went ahead and took the LSAT and I did fine and all that. But I really wanted to be a teacher and do political philosophy. And I convinced him that I'm happy doing that. He won't be making all the money that lawyers usually make. So that's the story.
I suspect that Dr. Trunick has a higher degree of personal satisfaction than the majority of lawyers in the country. And you can look at the numbers, especially young lawyers. Unfortunately, and that's why one of the other questions you had was, should you have a year or two out? I went straight through, but I really encourage that, and also just deciding, well, I'm interested in this kind of law, let me see if I can get, a job working there, and all of a sudden you see, oh, that's what they do? And I don't want to do that. So the question is, we have some, we have some lawyers here who, legal aid, they're not making the big bucks, but they're doing amazing things to make a difference. Rita, you were, right?
I was a public defender.
Public defender, you're now.
On my career prosecutor.
Yeah, so all the public service is also, I think they found actually that there's higher degrees of satisfaction of lawyers in public service than in private practice. So that's maybe hard to think of now if you have debt, like, oh my goodness, there's law school comes, unless you get a great scholarship, it's from crushing debt.
There's actually a flyer on your tables, and I think there's one outside. There's an event October 18th for those of you interested in careers in law. There'll be people here to help answer your question.
Oh, good, excellent. Okay, well, thank you for being such a great audience.
Let's just please give them a big round of applause.
I had a good feeling, but I didn't want to make an idiot. Take no matter what.
So what it takes to bring that approach.
You gotta do it. You do a job here.
I already have a job.
Become a mini official. I don't want to be Philly's VP though. That sounds scary.
Thank you, sir.
Finally got it.
Good week. But I have read all the cases. So I did. It's just I heard you. Apparently I missed out something good. I still don't know which is ever to go down on. I'm comfortable on both. Tunic just told me that you have 3 spots left. And they usually hate how we wait till last second to pick a team. That's because The thing is that also the school that usually beats us already has their team from the beginning of summer. Actually, maybe once. And to be fair, the only team I ever lost to was the one that ended up winning the whole thing. So I just when I see them, I know who they are. It's like, oh no, time for the robots to come on.
You're an excellent representative.
Well, so what are the Thomas College games again? Back and hard. That's the one out of my head. That was was it just